Juris Vodcast with Scott Pierce.
In a coarse display of judicial activism, the U.S. Supreme Court has gone out of its way to replace a bright-line Sixth Amendment rule with a new, vague standard designed to give the benefit of the doubt to law enforcement. The case is called Montejo v. Louisiana. It's a death penalty case. The defendant was convicted of murder, largely as a result of evidence obtained by highly coercive questioning by police, outside the presence of, and without notice to, his court-appointed legal counsel. This case came to the Supreme Court because the Louisiana courts had allowed the evidence to come in. The defendant had not affirmatively assented to the appointment of counsel. All of the U.S. Supreme Court justices agreed that the Louisiana approach was unworkable. Instead of simply reversing the defendant's conviction and sending the case back to the state courts, 5 justices decided instead to reverse the precedent that the Louisiana courts had struggled with. The case they overturned is Michigan v. Jackson. This is a 1986 case that held a defendant's Sixth Amendment right to counsel requires law enforcement not to question the defendant unless the defendant initiates the conversation. The majority assert that Jackson is untenable as a theoretical and doctrinal matter. This is an ideological decision by its own terms. They throw out a 25-year-old precedent without offering any substantial justification. Montejo v. Louisiana takes away well-established rights and gives us nothing in return.
Juris Vodcast is a production of Nuclear Podcasting. Creative Commons Attribution Non-Commercial No Derivatives.